All right, this is Antonio with Team Tiggio. Thank you for coming back to the channel. We have been doing a lot of videos on court cases. Personal family cases has been a hit. People are really loving these type videos. I don't get a kick about people exposing their personal lives, but this is the day and age that we are living in, where you're not going into a courthouse talking to a judge. Everything is being done in front of Zoom. The court system is taking plenty advantage of what's going on. In this case, mom hand has been caught in the cookie jar. She knew she signed a prenuptial agreement back in 1991, but she has been claiming some of dad's money ever since their split. Daddy discovered, because he forgot about this prenup agreement, he discovered the prenup agreement, and now he wants to stop paying. Let's see how the judge decides. Stick around and see the ending. Not a very long video, but nevertheless, okay, hold on. Let me remove this. All right, so let's go ahead and let's go ahead and okay, let's remove that. All right, so now, all right, here we go. Here we go. Okay, one moment. Let's make sure this is being played. Okay, let's make sure. All right, let's remove the scene and let's go back to the scene. All right, so let's start here again.
We have two motions before the court: the plaintiff's motion to reopen proofs for newly discovered evidence and defendant's motion in limine. Mr. Schaefer, you can proceed, and why don't you address both of them at the same time? We don't have to jump back and forth.
I think the record is clear, at least from our perspective. We have discovered the prenuptial that was signed in 1991, just prior to these parties getting married, which addresses the spousal support issue in paragraph 7. That was discovered pursuant to the affidavit after the proofs at the trial level have been completed and during the process that defendant had appealed the ruling of the court. At the status conference, I made that known to the court, and I at that time emailed a copy to the other side and so forth. I think it's appropriate that prenuptial be considered at the time that there's a hearing on the issue of spousal support that was remanded back to the court for further testimony. It certainly has relevance to a lot of the Olson factors. So I wanted to be transparent up front. So that's why I brought the motion to reopen in relation to that particular matter. And that's our position on both of these. There's nothing that is nefarious. It was an interesting argument on the other side that apparently I did something that was unethical, of holding back a prenuptial. If I have had the prenuptial, it would have been there at the time of the trial. It was very relevant at that time. It was just not found. And after an effort to go through many cupboards and shelves of records, it was discovered. And I don't think there's any question that it's authentic. And at least I haven't heard that argument up to this point. So I think it's relevant. The court didn't give it whatever weight it wants, but it's certainly relevant to the spousal support issue. Thank you.
Thank you. Ms. Capture?
Thank you, Your Honor. First, I would like to state that I think there was a misrepresentation by plaintiff here. The spousal support issue is not before the court. In fact, the Court of Appeals was very specific. The only thing the court is supposed to be doing is balancing the parties' incomes and needs. Those incomes and needs have already been presented to the court during the course of the trial in this case. And therefore, the spousal support itself is not at issue. The factors have already gone through. The prenup would have been an objection or a defense, perhaps, to spousal support, but it was never raised during the course of the proceedings. It was apparently located back in August of 2023, which would have given plaintiff plenty of time to file a motion in this court to state proceedings of the, to at least present the spousal support claim that it was barred. Again, we haven't addressed the authenticity or enforceability of the prenup because it's not an issue in this case. The parties have gone through an entire trial, have gone through an entire appeal, and the Court of Appeals has stated that they only vacated the alimony and gross award, not that they vacated any spousal support ruling. Again, the motion in limine that we have presented is based on a standard that evidence should be presented about issues that are relevant, material, and admissible. To quote People v. Mills, which is referenced in our brief, if the evidence is offered to help prove a position which is not a matter in issue, the evidence is immaterial. And again, Your Honor, the spousal support is not at issue. The prenup, therefore, cannot be material to helping balance the parties' incomes and needs. Lastly, Your Honor, or moreover, we have stated that plaintiff has waived his right to bring the prenup. This is a concept, the raise or waive concept is something followed in Michigan courts. People v. Pipes states that in order to properly preserve an issue for appeal, a defendant must raise objections at the time when the trial court has an opportunity to correct the error. Again, we have gone through an entire trial in this matter. Plaintiff had numerous occasions to bring up the issue of a prenup and never did. He states that in his response to our brief that defendant had an opportunity to bring the prenup, but defendant was never requested during the course of discovery to present a prenup. And if we did have a prenup, we would have presented it. We didn't have any location. Apparently it was difficult to locate, which is why it took them until August, allegedly, to locate the prenup. However, once located, it did not come across our desks. It didn't get presented to the trial court when it should have. Again, Your Honor, the issue in this case is very limited. The parties' incomes and needs have already been presented to the court. There's been ample evidence presented, and this is simply a new issue. The plaintiff has created costs and additional hardship on defendant. It's clear that plaintiff is utilizing his superior financial condition and more extensive resources to out-litigate defendant, and that should be sanctioned, Your Honor. This is a clearly frivolous motion. Its standing has simply no court rule, no case law, nothing in support of it. It disregards court rules that are directly on point, which state that new evidence that would require a new trial, because this simply would require a new trial, is barred after 21 days. And yet, plaintiff has now filed a motion to reopen proofs. Again, Your Honor, the allegations that this potentially could be an enforceable or authentic prenup can't even be addressed here. We would need to open an entirely new trial, because our approach would be completely different had we been presented with a prenup when it was appropriately supposed to be presented. The costs that would go into having an entire evidentiary hearing on the authenticity and enforceability of the prenup would also be extensive. And again, defendant is not full of money. That is the whole reason we're here. We need spousal support. The spousal support that was awarded previously was inequitable and unfair to defendant, and she is essentially barely getting by having to dip into whatever property award that she was given. So, Your Honor, we're asking for costs and fees in this matter as well, and sanctions for having to present these arguments today. Thank you.
Thank you. Well, in this case, the court has read all the pleadings, and court does note that, again, there was no ill will or nefarious basis by plaintiff for presenting this motion at this time. Clearly, if they could have brought it up at the time of trial, they would have, as that would have directly addressed the issue of the spousal support. And there's multiple cases that discuss newly discovered evidence that was not able to be discovered at the time of trial, which they weren't, or the court does believe they would have brought it up at that particular time. A prenuptial agreement would be applicable to the factors under Sparks v. Sparks at 440 Mich 141 and 1992 case, which the court must consider as whether to grant or deny spousal support. And so as a result, the court, recognizing the defendant's objection, would at this point grant plaintiff's motion and will consider the prenuptial agreement at the time of the remand hearing. And as a result, the defendant's motion in limine will be denied at this particular time. I'll ask Mr. Schaefer, you prepare an appropriate order, and should there be any need for, I know we're set sometime in May, I believe, if there's some additional time, Ms. Capture, that you are needed because of this, the court would entertain that motion to again adjourn and extend the hearing in this matter. With that, you're free to go. Have a good day.
Thank you, Your Honor.
Thank you.
Okay, so as you can see, all of that rambling that she did to stop Dad from being able to enforce or at least present his evidence of a prenuptial agreement was denied, and the plaintiffs was able to present the evidence at another trial. If I discover or come across the follow-up of this trial, I would definitely make sure that I list that information and react to that video as well. Nevertheless, this is Antonio with Team Tiggio. Please like, comment, subscribe, as we will come to you another video in the future. And once again, we will see you in the next video. Make sure you hit that notification bell, as we'll be coming to you more videos in the future. And once again, we will see you next time.